Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we picked up a couple of important articles from the Hindu which are very significant from your UPSC and your KPSC examination point of view. Before we start with our today's analysis, a quick gentle reminder. Spardha Lines team has been conducting a test series for all those of you who are planning to take up CTI, PDO and the KAS exam. This test mode will be both on the offline and the online mode. For this test series, we've already conducted two tests. The next one will be tomorrow, which is on 10th of December 2023, and this test is completely free of cost. So what are you waiting for? Join the test series and understand how exactly the real-time examination works for such ones like the CTI, PDO and KAS examinations. Let's get started and look into the first MCQ and the first article for the day. Consider the following statements with respect to the writ of habeas corpus. Locus standi is needed in case of habeas corpus. The writ does not lie to secure the release of a person who has been imprisoned by a court of law on a criminal charge. Which of the statements given above are correct? The answer to this is 2 only. Why have we taken this practice question? That is because this article on the Hindu makes a reference to the writ of habeas corpus, which is why we have taken this practice question. Let us try and understand what are these statements. When you look into the first statement, it says locus standi is needed in case of the habeas corpus. No, this statement is wrong. Why? That is because when you look into habeas corpus, what is it? It is to bring a person's body. Literal interpretation from Latin to English is to bring the body of a person. What is locus standi? Locus standi is whether I am directly involved in that particular case, whether I can file a case in that particular situation or not. When it comes to habeas corpus, what exactly happens? Let's say, for example, I am a person. I might have committed an illegal act or I might not have committed an illegal act. I am taken by the executive investigating agencies and I am thrown behind bars. What is the ideal procedure for the police officers to do? Within 24 hours, they have to produce me before the magistrate or before the sessions court. If they do not do, they are violating the procedures established by the law. So what happens when it comes to habeas corpus? Whenever the police arrest me, they immediately will have to take me to the relevant magistrate within 24 hours. If they do not do so, it means they are violating the procedures established by law. What happens in the writ of habeas corpus? In writ of habeas corpus, remember, it can be a public official or it can also be a private individual as well. What do I mean by public official? Let's say the police officers. These are the institutions or the officers who are established by the constitution and by the law. And as a result, whenever I am arrested, the public official, which means the police officers, will have to take me to the magistrate immediately within 24 hours. Is it only restricted to the public official? No, even if it is a private individual. Let's say, for example, I am a person who is, let's say, kidnapped by another individual. So in that case, it is a private party, not a public party. Public party, when I say, an institution represented by the government, an institution established by law. But if there is a person who has kidnapped me and the court issues an order to that private individual, produce the body of so and so person before the court of law. So remember, habeas corpus is for public individual as well as for the private individual as well. Now what happens? So there is a direction issued by the court that bring the body of this particular person. So it can be both public individual as well as the private individual. That's the first important factor. The second important factor is, now I am, let's say, taken up by the police officers and put behind the bars. Ideally within 24 hours I should be taken to the magistrate, but I'm not produced before the magistrate. So there is a violation of a procedure. So I would not be able to speak for myself because I'm behind the prisons. So I can ask my parent, I can ask my sister, I can ask my friend, anyone who is associated with me directly to file a writ. In this particular case, even though I am supposed to do it, that is what is locus standi. If something is harming me, I am the one who is directly supposed to file a case, but in this case I am behind the bars. So despite me having the locus standi, I am not able to file a case. So someone else on behalf of me is filing a case. So is locus standi required for habeas corpus? No. Even if someone else feels that there is a violation of the procedure established by law, they can ask the High Court to issue directions in the name of writ of habeas corpus. So locus standi is not needed in the case of habeas corpus. So remember, the first statement is wrong, which is locus standi is needed in case of habeas corpus. No, not necessary. Locus standi is not necessary for habeas corpus case. Why? That is because despite a person having no connection, if he feels that there is a procedure violation, if he feels that a person is not produced before the magistrate or before the court within 24 hours, they are violating the procedure established by law. In that case, they can just ask the person to produce it, and that is where locus standi is not required. So the first statement is wrong. The second statement reads, the writ does not lie to secure the release of a person who has been imprisoned by a court of law on a criminal charge. What is habeas corpus? It is to produce the body of it. But then if a person's conviction, if a person's trial make sure that this person has committed an offence, in that case he has been imposed with a penal provision, he has been imposed with a punishment, he is being convicted as well. In this case, writ of habeas corpus does not do. So in the case of producing the body, yes, it does work, but when it is convicted by the court of law, in that case it does not work, because the court of law has convicted that individual. So writ of habeas corpus does not apply. So if you look into what is this writ of habeas corpus, it is a Latin word to mean to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. So the person can be a private individual or a public individual. The writ of habeas corpus can be issued against both public authorities as well as the private individuals. I did give you an example that what if I am kidnapped, I've been kidnapped by another individual. So the court issues directions to the private individual, bring this person or else you will also be thrown behind bars. So it is for both public as well as private. So the writ on the other hand is not issued where the detention is lawful, proceedings is for the contempt, detention is by a competent court, or detention is outside the jurisdiction of the court. These are some of the important parameters with respect to the writ of habeas corpus. Now let's look into the next practice question and the article. Which among the following statements regarding double membership in the parliament is correct? If a person is elected to both houses of the parliament, he must intimate within 10 days in which house he desires to serve. In default of such intimation, his seat in the Lok Sabha becomes vacant. If a sitting member of the house is also elected to the other house, his seat in the second house becomes vacant. If a person is elected to 2 seats in a house, he should exercise his option for 1. Otherwise, both seats become vacant. Similarly, a person cannot be a person of both the parliament and state legislature at the same time. If a person is so elected, his seat in the parliament becomes vacant if he does not resign his seat in the state legislature within 14 weeks. Which of the statements are correct? All the 4 statements that are given here. Amongst this, which is the right statement? The answer to this is C, which is if a person is elected to 2 seats in a house, he should exercise his option for 1. Otherwise, both the seat becomes vacant happens to be the right statement. Why are the other 3 statements wrong? Let's look into it. Why are we speaking about it? Because this article on the Hindu speaks about double membership. So when we speak about double membership, what does it speak about? It means that a person is a member of 2 houses. It can be the Rajya Sabha or it can be Lok Sabha, both the houses, or a person is a member of Lok Sabha or he is a member of Rajya Sabha and also happens to go on to become the member of Legislative Assembly or the Legislative Council. So that is double membership. So he is member of the parliament, he is member of the legislature. Within parliament, he is member of the Lok Sabha and Rajya Sabha. So in this case, he has double membership, which is not allowed as per the Representation of the People's Act of 1951, which is why he has to resign to one of the houses and ultimately be part of only one house. That is what is called as double membership. Now, if you look into the options, the first option says, if a person is elected to both houses of the parliament, he must intimate within 10 days in which house he desires to serve. That's the right part. In default of such intimation, his seat in the Rajya Sabha becomes vacant and not the Lok Sabha. Why does his seat become Rajya Sabha vacant? That is because when you consider the Lok Sabha, it is the opinion of the general public. It is the opinion of the larger audience which are present, and as a result, since he is elected by the general public by contesting an elections directly where people are electing him, that has the majority, that also has more viewpoint as well, that has the real representative character, and as a result, his seat in the Rajya Sabha becomes vacant and his seat in the Lok Sabha continues to be present, and which is why the first statement is wrong. It is not Lok Sabha, instead it is Rajya Sabha. So the first statement is wrong. When you look into the second statement, if a sitting member of one house is also elected to the other house, his seat in the second house becomes vacant. Common sense. Why? Because he is opted for the second house. Why will the second house become vacant? It will be the first house which will become vacant. He is already a member of one of the houses. He goes on to become the member of the second house. While he wants the second house, why will that become vacant? It is the first house which will become vacant. So it is not the second house which becomes vacant, but instead it is the first house which becomes vacant. So second statement is also wrong. Third statement is right. Similarly, when you look into the fourth statement, a person cannot be a member of both parliament and state legislature. Yes, this is right, but it is not 14 weeks, but instead it is 14 days. And as a result, the first, second and the fourth statements are wrong. The third statement is right, which is why the answer to this would be C. Now let's look into the next practice question. Which of the following statements are incorrect? A private member's bill is a bill introduced into a legislature by a legislator who is not acting on the behalf of the executive branch. In the Rajya Sabha, an MP can give a maximum of 3 notices for the introduction of private member's bill during a session. Which of the statements are incorrect? Since it is asking for the incorrect statement, the answer to this is none. Why? That is because both the statements are right. Why have we taken this practice question? Because this article on the Hindu makes a reference to the private bill, which is why we have taken this practice question. Let us try and understand what are these statements, and we will explain you what is this private member's bill. A private member's bill is a bill introduced into a legislature by a legislature who is not acting on behalf of the executive branch. Yes, this statement is right. What do we mean by it? What is a private member's bill? Let's say, for example, I am elected as a member of the parliament. So what do I become? I immediately become the legislature. So all those members who become the members of the parliament, they immediately become part of the legislature. Who go on to become the part of the executive? Let's say, for example, one of the political parties, they form the government, and after they form the government, there are few people who go on to become the ministers, or they become the part of the cabinet or the council of ministers. So those who become the part of the government and ultimately go on to become the cabinet or the council of ministers, they become the executive branch. So if a member of the parliament who goes on to become the part of the council of ministers, if they introduce a bill, that is what is called as the government's bill. Any other person who introduces a bill is called as a private member's bill. So this person can be a part of the government, that is, he can represent a political party, but he is not part of the council of ministers. Is this a private member's bill? Yes, it is a private member's bill. Only the ministers and the prime minister or the member of the council of ministers, if they introduce it, that is what is called as the government's bill. Despite this person being from the same political party, if he is not a member of the council of ministers, introduces a bill, even that will be called as a private member's bill. So the minute a person is elected as part of a legislator, he is a legislator, it is a private member's bill if he is not part of the council of ministers. So what does the first statement read? A private member's bill is a bill introduced by a legislator. I am an MP, I become part of a legislature by a legislator who is not acting on behalf of the executive branch. So any person who is not a minister, is not part of the council of ministers, whosoever is the person who introduces it, that bill will be called as a private member's bill. Even if he is part of the same political party which is formed the part of the government, that person will still be called as a person who is part of the legislature but a private member's bill. So the first statement is right. When you look into the second statement, in Rajya Sabha, an MP can give a maximum of 3 notices for the introduction of the private members bill during a session. What does it mean? During a session, let's say for example, we have a winter session, we also have the, let's say, monsoon session, so on and so forth. In this case, a person will be able to make a representation that he makes a representation saying that he wants to introduce a bill. So for a maximum of 3 times, he would be able to make a mention, not beyond that. So the second statement is also right. So both the statements are right, but the question is asking for the incorrect statement. Since both the statements are correct, that is why the answer would be none, because it is not incorrect. So that is why we have taken up this practice question. Now let's look into the mains related topics. This article here is speaking about India's alarming fixed dose combination problem. First, we have to understand the meaning of the fixed dose combination. What is this fixed dose? Let's say for example, you have a fever. What do? You take a tablet. This tablet has something called as the active pharmaceutical ingredient. This active pharmaceutical ingredient is nothing but a chemical. So the minute you have fever, or let's say you have cold or you have cough, what do? You take a tablet, you take a syrup that has a chemical component or an active pharmaceutical ingredient which is able to control or even prevent, and in fact is able to reduce the temperature, and your fever goes off. Or similarly, if you have let's say cough, there is one single active pharmaceutical ingredient. So in a tablet, in a drug or in a syrup, you have one single active pharmaceutical ingredient, or you have one single chemical which is present, which is ultimately able to reduce the cold, cough or your fever. That is what is called a single one. But what if you have fever and cough? So in a single tablet, so you're not taking one tablet for cold, you're not taking another tablet for cough, you're not taking another tablet for fever, but these 3 different chemicals or the active pharmaceutical ingredients are mixed into one single tablet. Let's say you have fever, you take one active pharmaceutical ingredient tablet, your fever goes off. But what if you have fever, cold as well as cold? You don't have to take 3 different medicines. You have the option of taking 3 different medicines, but what if you forget? So in order to prevent that, these 3 ingredients which are present in 3 different tablets are present in one single tablet or a drug or a syrup, is what is called as a fixed dose combination. So it is a combination of active pharmaceutical ingredient which is present in 3 combinations ingested or mixed into one single tablet, which is called as the fixed dose combination. So what is a fixed dose combination? You have an active pharmaceutical ingredient. This active pharmaceutical ingredient, 1, 2 or 3 chemicals, 3 different active pharmaceutical ingredients are present in one single tablet. So you don't have to necessarily take 3 different tablets, but instead if you take one single tablet, all these 3 issues are addressed by one single tablet, which is what is the discussion of this particular concept. For example, if I have to give you an example of the fixed dose combination of a HIV drug, there will be effervescence, then there will be ematricitabine, then there will be tenofovir, which will ultimately become atripla. So this means that this is a one single combination which could have been for something. This could have been another combination which could have been given for something else. When all these 3 combinations together are present in one single tablet, that is what is fixed dose combination. A combination of active pharmaceutical ingredient, 3 different chemicals present in one single combination, one single drug, is what is called as the fixed dose combination. Why are we discussing about it? That is because a group of academics from India, Qatar and United Kingdom recently published a worrying new study in the Journal of Pharmaceutical Policy and Practice on the volume of unapproved and even banned fixed dose combinations of antibiotics that are being sold in India. Using sales data of pharmaceutical industry, the study documents that in the year 2020, 60.5% FDGs of antibiotics were unapproved and another 9.9% were being sold despite being banned in the country. What do we mean by it? Let me simplify this entire process for you. Let's say for example, you have a drug. Let's say you are suffering from fever. Whenever you are suffering from fever, what do? You take a drug, and this drug will ultimately wave off, or it will release the temperature, and ultimately you are not having the temperature anymore. But if this active pharmaceutical drug has to be given permission to be released into the market, it has a stringent procedure. Number of clinical trials will have to be conducted, number of procedures will have to be followed, number of patients and animal testings will have to be done, and ultimately after all stringent procedures are followed, that is when the permission will be given by the central government. But what happens in the FDCs? In the FDCs, there is no clear-cut procedure that has been laid. So what if there is a person or an organization which does not want to fall into this category where stringent provisions have to be followed? So they don't have to come with a medicine or with a drug where only one pharmaceutical, that is one active pharmaceutical ingredient is present. So what do? They come up with the FDC. For a single API, that is the active pharmaceutical ingredient, there is a stringent procedure that has been laid by the government. But what if it is a FDC, which means to say fixed dose combination? In that particular case, the procedures are kindly diluted, or there are no procedures, or even in fact less procedures that are present for the FDCs. In that particular case, why would I want to go towards the active pharmaceutical ingredient and a single drug? Instead, what do? I'll come up with the FDC. For the existing let's say for existing tablet or a drug or a syrup, I just add an other component. I'll declare myself that this is not a single medicine, but it is a FTC. So the minute I declare my medicine as FTC, I don't have to follow the stringent procedures. So what do? I go for this categorization rather than that categorization. In a single active pharmaceutical ingredient drug, there are stringent procedures that I have to follow. My drug may not get the permission to be released into the market. So instead, I follow an alternative. I say it is not a single API, but instead it is a combination where stringent rules are comparatively reduced, and as a result I introduce another combination, and which is why there is persistence of the FTCs which are more into the market rather than one single drug. So the author in this particular case goes on to say that you have number of pharmaceutical companies who are making use of this legal loophole and ultimately are coming up with a product and designing a particular product on the basis of FDCs, which is ultimately harming the country. How is it harming a country? Whenever we are speaking about drugs, there could be a possible likely side effects or repercussions because of that particular drug. I consume a drug, it may result in a side effect in a longer run. Why? Because it is made of a lot of chemicals. But what if it is a FTC? So there are 2-3 active pharmaceutical ingredients which are present. So in all likelihood, it may create side effects, it may create something of a disturbing nature. So this FTCs, when constantly consumed by the people, what it could result is into side effects, more side effects, and added to it, if it is to do with the antibiotics, what would happen? This could also lead to antibacterial microbial resistance. So if a particular drug is being ingested or being consumed by an individual for a very long period of time, the body may not be receptive to that particular medicine, and as a result that drug will become immune to the bacteria or to the viruses, and ultimately antimicrobial resistance comes into the picture. So the author in this particular case goes on to say that since there is a legal loophole that is existing with respect to the FTCs, pharmaceutical companies and organizations are making use of the legal loophole and ultimately not producing one single drug. They're using a combination, and as a result of this combination, because there is a legal deficiency, lacuna, and the vacuum that is created, they are releasing a lot of products into the market which could have side effects, which could have the antimicrobial resistance, is what is the author trying to convey through this article. So one such law is the Drug Prices Control Order, under which the government fixes the prices of individual drugs. Since drug combinations were traditionally not covered under the DPCO, the pharmaceutical industry decided that making FTCs provided an easy way to escape the remit of DPCO. For example, anti-inflammatory drugs were combined with vitamins, antihistamines were combined with antidiarrheal agents, penicillin was combined with sulfonamides, and vitamins were combined with analgesics. They were combinations not found in any other country. Just because they wanted to get away from this legal recognition, they have been coming up with combinations after combinations which is not even heard of in another country. In another country, we do not find such bizarre combinations. We do not have all these unlikely combinations, but it is existing in India, says the author. The fact that because of the bewildering variety of FTCs being sold in the market. There were no standards set by the bodies such as India Pharmaceutical Commission for testing these drugs for quality of manufacture. And the second advantage of going to the FTC route is that it gives individual companies a reason to charge higher prices for their drugs. So why do companies go ahead with it? That is because of two reasons. One, because there is a legal loophole. There is no one standard procedure that is established. There is no standard quality testing procedure when it comes to the FTC, and as a result these companies would want to make use of it. And at the same time, if it is a single drug, all I can do is charge a basic minimal amount. But if it is a FTC, fixed dose combination, I can also charge exorbitant rates as well. I would be able to generate more profits. So it is easy for me as a drug manufacturer and a pharmaceutical company to charge more and also prevent the legal loophole. The FTC problem has been on the regulator radar since 1978, when the first government committee studied the issue and admitted that we had a problem on our hands. At the same time, there was no drug system of the colonial drug errors and the cosmetic acts. It was not able to look into the safety. And what happened? Because there was no central regulatory mechanism that was imposed, states were given the power. Since it comes under the state government, there is no one organic or the holistic law that we have at the central government for the regulation. States, as their own whims and fancies, they would have their own standard procedure. This procedure may be different to another standard procedure. One may have stringent rules, other may have lenient rules, and as a result the manufacture bases would be set up in such states which would have lenient rules, and they would come up with a particular product. And this particular product, if it is allowed in one state, this product that is allowed will also be released in another state, and this could also have likely consequences and disastrous consequences. And as a result, central government does not have one single law for this entirety, but states give the permission. This could have likely repercussions, says this article. Further, in 1982, Parliament changed the law to give the central government the power to prohibit the manufacturing of specific drugs that lack therapeutic value or justification. Later in the decade, the central government amended the rules to introduce new requirements for manufacturers of all drugs, including FDCs, to submit proof of safety and efficacy to the Drugs Control General of India, who heads the CDSCO. These amendments also made it clear state drug controllers could not grant manufacturing licenses for new drugs that are not approved for safety and efficacy of DGCI. Despite the law being crystal clear on the issue, we have the state drug controllers having simply ignored the law to continue issuing manufacturing licenses for FTCs not approved by the DGCI. So because of the legal loophole, the states continue to make use of it. They continue to explore this option and ultimately give permission despite a validity that has to be given by the central government, but they are not being followed. So instead of ordering criminal prosecutions, the Ministry of Health is playing a game under a back-off hole by invoking its powers under Section 26A to prohibit the manufacturing of specific FTCs. It has also issued 444 orders under this provision, banning mostly FTCs. Many of these orders have been embroiled in complex litigation, with the courts muddling the waters with inconsistent decisions. So there is the legal lacuna, and as a result, orders are being issued by the executive. One order, when it goes to the court of law in a particular state, the order and interpretation may be different. It goes to another court in a different state, the order and recommendation given by the directions issued by the court will also be different. So there is no homogeneous law that is being associated with, and there are different interpretations given by the court, and this is ultimately leading to the loss of the country. Why? Because there is no one single regulation mechanism, and as a result, unregulated FTCs may contribute to the antimicrobial resistance problem in India. So it is vital for the Ministry of Health to take immediate action, says this article. So because we do not have one single organic law at the central level, states are being taken for the toss, where they have been giving different permissions, and ultimately there is no check, and as a result what we have is the antimicrobial resistance increasing, says this article. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says, bridge this deficit between India and Sri Lanka. The article here is speaking about the relationship between India and Sri Lanka. One, it speaks about the economic relations. Second, it speaks about energy relations between India and Sri Lanka. Third, it speaks about trade relationship between India and Sri Lanka, and ultimately it says that we have had discrepancies between India and Sri Lanka's relationship on the economic front, on the energy front, on the trade related front. If we are able to establish and recoup and remetallicize this entire issue, ultimately we would be able to check the imbalance that is existing between both the countries. So what is the context? The announcement by Sri Lanka's President Ranil Wickremesinghe recently about a proposal to establish land connectivity with India has none too soon 20 years ago. What does this mean? This means that in the past, India and Sri Lanka wanted to establish an infrastructural development. What did they want to do? They wanted to bring a land connectivity project between India and Sri Lanka with the state of Tamil Nadu in India and the state of another state in Sri Lanka. So they wanted to ensure that they build a bridge linking Rameswaram in Tamil Nadu with Talaimanar in North Province of Sri Lanka. So there might be a question, Talaimanar was recently in news. It is part of which country? It is part of Sri Lanka. It is on the northern side of Sri Lanka. So they wanted to build a physical corridor between India and Sri Lanka, that is between Talaimanar in the North Province of Sri Lanka. This was part of the larger vision of regional economic integration. Was it successful? No. Why? That is because even in the past as well, we have taken up initiatives that will ultimately bridge the differences between both the countries, but then there have been the Sinhalese majority in Sri Lanka which may not have allowed. That is primarily because it feels that India is like an elder brother, big brother attitude which will not allow Sri Lanka to flourish. It's a general perception that Sri Lankan few Sinhalese have, not all of them. Few of them have this particular perception that there is big brother attitude that India showcases, and ultimately whenever a good initiative is being brought about, these people ultimately stop it, primarily because they feel that this sort of integration should not happen. One is that. The second also happens to be because of the influence of China. China basically also has some good partners in Sri Lanka. So whenever a project is being executed between India and Sri Lanka, because of the influence of China, many people do not want India to play a card in Sri Lanka. So they have also been opposing it as well. So in the December 2015, when India's Road Transport and Highways Minister Nitin Gadkari informed the Lok Sabha that Asian Development Bank was willing to fund a bridge project of 24,000 crores, Sri Lanka's response was muted following the project initiation. So there have been initiatives that have been taken in the past, but then they have not become successful because of the constant voicing of few Sinhalese Buddhist majority country people, and as a result this project has been abandoned. So these kind of issues should be addressed is the first point. The second point is with respect to the case of a power grid. What does it speak about? It speaks about energy and the electricity. So the author in this particular case goes on to say that when it comes to India and Bangladesh, what we have already been able to establish is the power grid between both the countries. So because of the power grid that we have been able to establish between India and Bangladesh, what we've been able to do, create goodwill in Bangladesh. We've also been able to ensure that we have electricity both to Bangladesh, and because we have assisted them, the northeastern part of India is also provided the electricity as well. So the author takes into picture a couple of examples. Mr. Modi and Bangladesh Prime Minister Sheikh Hasina jointly commissioned in virtual mode the second unit of Rampal Maitri power project. So this Rampal Maitri power project, there can be a question in prelims, is between which two countries? Is it between India and Nepal, India and Bangladesh, India and Myanmar, India and Sri Lanka? So remember, Rampal Maitri power project is between India and Bangladesh. So what did they do? They launched this power project, and ultimately it is providing power to both India as well as Bangladesh. So the author in this particular case says, in Bangladesh we've been able to do so. We've been able to establish energy grid, power grid. But this is not the same with respect to Sri Lanka. Despite having talks from 1970 that we have to create a power grid so that there is no power crisis in Sri Lanka. Recently, if you remember, there was a lot of economic crisis in Sri Lanka. power blankouts took place. They did not have power for a very long period of time. Exponential rise of the basic products. Gas cylinders became exponentially raised, and at the same time they did not have enough food as well. One is because of the external factors, the other is because of the internal factors. On the external factors, tourism was not happening for Sri Lanka. That happens to be one of their main coffers for the government. But since COVID-19, a couple of bomb attacks and other things had taken place in Sri Lanka, they did not have enough currency that was inflowing. That is external sector. But when it comes to internal sector, for example, their policies did not work, or for example, there was exponential inflation as well. All this led to the economic crisis in Sri Lanka. So had the energy agreement between India and Sri Lanka worked out, they could not have seen the blankout. And who is responsible for it? It is the policies of the government. It is the government which has to ideally take up this decision, bridging the differences between India and Sri Lanka. Since they did not do so, they had to be left with less electricity, says the author. Had they decided that we would have had proper electricity in place, we would not have faced such issues, says the author. In fact, he goes on to say, yet the progress of transmission network project envisaging the transfer of 1000 megawatts and the establishment of high voltage direct current overhead link between Madurai and New Habrana does not reflect well on the two countries. Had the facility been in place, Sri Lanka would not have suffered the blackout, says the author. Next, the author takes into picture on trade relationship. So the author says that because of the drop in the tourism, we are not able to make any contributions to Sri Lanka on the external factor, because Sri Lanka's 17% and more of the GDP is basically concentrated on the basis of arrivals of the people. So on the basis of trade, we have to ignite more between the countries. Notwithstanding several constraints, even now bilateral economic ties seem to be better footing with India, regaining its position last year as the largest source of imports and accounting for about 26% of the total imports of Sri Lanka, though certain portions of imports were through credit lines. So we have to expand on the import and the export front, says the author. And finally, with respect to Sri Lanka, the momentum generated by certain developments, for example, resumption of air services between Chennai and Jaffna, launch of the passenger ferry services between Nagapattinam and Kanisanturai, a joint venture agreement among India's National Dairy Development Board, the Gujarat Cooperative Milk Federation, has been where there is self-sufficiency. Despite all these efforts, we have to further increase the efforts between these two countries, is what is this article all about. Now let's look into the next article. This article is important from your mains examination point of view, where it is acting as a fodder for your mains answer writing. Judges should not preach. Supreme Court on Calcutta High Court's advice to girls. So the Supreme Court has said judges are not expected to preach or express personal views, even as it took exception to remarks in Calcutta High Court judgment advising adolescent girls to control sexual urges. So whatever the judges have to do have to be only within the contours of the Constitution and law. Their moral viewpoints and subjective interpretations of the judges should not be given, said the author. So the High Court bench of Justices Chitan Ranjan Das and Partha Sarathi had observed in October 18 judgment due obligation to every female adolescent to protect her right to integrity of her body, protect her dignity and self-worth, thrive her overall development of herself transcending gender barriers, control sexual urge or urges as in the eyes of the society. She is losser when she gives it to the enjoyment of the sexual pleasure of hardly 2 minutes, protect her right to autonomy of her body and her privacy. These are the words that are not expected of, and the court should be generally not giving any moral lessons, but instead it should stick to the law and contours of the Constitution, and ultimately judges should not preach, says the Supreme Court of India. So you can use this whenever you're writing your answers in your mains answer writing. So this is it for today. Thank you for watching. All the best.